Hello, everybody. On this Monday, March 14th, I'm Spencer Mazyck, and this is the Bloomberg Law podcast, a series of interviews focusing on trends in the busy legal profession. In a letter dated February 23, 2011, a group of more than 100 law professors asked Congress to implement an ethical code of conduct for the Supreme Court. And this really got me wondering, does the Supreme Court need a code of ethics? Well, joining us in studio to answer that question and many more on the topic is John Leubsdorf, a Rutgers Newark Law School professor and Judge Frederick B. Lacy scholar. Welcome, Professor Leubsdorf. Thank you for joining us today.
It's nice to be here.
So, Professor, I see your name here on page 7 of this letter to Congress. So I know that you signed it, but tell me, why are you and other law professors across the nation asking for a mandatory code of ethics for the Supreme Court?
Well, virtually every court, every judge in the country is subject to a code of ethics, except the Supreme Court. And it seems to us that the time has come for the court to have a code. The justices of the court are at least as likely as other judges to get involved in questionable or borderline activities, and it would help them to have some guidance that they could follow.
Well, yes, but how did this letter come about? Is it because of the controversy over meetings that Justices Scalia and Thomas had with conservative groups?
I think that might have been the cause for some people, but some of us who teach in the area have been worried and thinking about this for some time, because the decisions made not just by Supreme Court judges, but by appellate federal judges on a matter such as whether to disqualify themselves or how they should behave are basically subject to no review at all. The judge makes the decision, at least as to disqualification. In the case of other activities, an appellate judge could ask for an advisory opinion from a body set up to do that, but a Supreme Court justice does not do that.
Well, and I don't know whether or not this was the impetus for the letter, but I do know that Common Cause, which is an independent, nonpartisan organization, filed a petition with the Department of Justice in January of this year, asking it to investigate whether or not the justices should have recused themselves in Citizens United because of the meetings that they attended. So what were these meetings, and why was their attendance so controversial?
Well, if we could answer your first question, we might be able to deal with the second. But as I look at this letter and at reports, what becomes clear is that no one knows very much about what happened. The meetings are apparently somewhat secret, so we don't know what the justices did there. We don't know whether these should be considered political or fundraising meetings. We don't know whether, and if so, how much the judges were paid. If we could answer those questions, we might, as very often happens, conclude this is not problematical at all.
And I should mention, though, that the meetings were sponsored in part by Federalist Society, which, of course, is an organization that receives some funding from Charles and David Koch. And so I want to ask you, though, about Citizens United. Just quickly, for folks out there who might not know what that case held, can you tell us what the holding was in Citizens United?
Yes, that case held that corporations have the same right to contribute to political campaigns under the First Amendment as individuals do. Those rights have certain limits, even in the case of individuals, but they leave the individuals and now corporations free to basically to contribute as much as they like, as long as it's not to official campaign organizations.
Yes, and what some people may not know is that since 1998, Koch Industry, which of course is owned and operated by David and Charles Koch, it's been one of the leading campaign contributors among oil and gas industry, alongside Chevron, Texaco, El Paso, and Enron. And I believe that some people said that even if the justices, if either of them had attended these meetings during a time when the Supreme Court was considering aspects of Citizens United, then it might raise some serious issues as to the appearance of impropriety and bias. Do you agree with that?
Again, I'd like to know what was happening at the meetings. I don't think the fact that you attend a meeting which is paid for by someone who is really interested in the result of a Supreme Court case is enough to raise significant concerns.
And we've talked about, I guess, the impetus for the letter, but tell me this, can you say with all honesty that this movement, this entire movement, is in no way politically driven?
I don't know about the motives of other people. Obviously, the people who wrote that letter don't like Citizens United, which is true of lots of us. I don't like it much myself. You can say that's political if you like. But historically, at least if you look at judge disqualification, the changes have always come about as a result of controversy concerning the behavior of a particular judge. For instance, one of the last recent changes in the disqualification statute resulted from the nomination to the Supreme Court of Judge Haynesworth in the Nixon administration. And it goes way back to the 19th century. So that's how change comes about in this area. It isn't as if Congress is waking up every morning and thinking, well, how can we improve the rules for judges? They act when there's controversy and when someone asks them to act.
Okay, and you're not asking for the creation of a new code of ethics for the Supreme Court. As you mentioned, I think you said that you're just asking that the justices, follow the standard that's already in play for federal judges, correct?
There is a code, but it explicitly does not include Supreme Court justices.
And would you like for them to comply with that code?
Yes, there are always controversial or difficult issues, but the code is an okay code.
Well, and if they were to comply with that particular code, then what would it mean for the justices in terms of travel reimbursements from outside groups?
There are already some rules about that as a result of a statute. A judge is not allowed to accept what the statute calls an honorarium for giving a talk. But the statute accepts travel expenses. So if the judge is accepting is giving a talk, there are rules. And if the judge is simply, say, going to teach, which is a legitimate activity, he's, of course, able to accept pay for the teaching, unlike the honorarium for the talk, and that might include reasonable travel expenses.
But would the justices be able to attend overtly political meetings?
Probably not. If you include in overtly political meetings in which fundraising is going on, or meetings organized by a political party. Mm-hmm. You used political in a fairly broad sense before, so I wouldn't say that a debate about Citizens United is something that a judge could not attend.
But what if the meeting was then sponsored by, say, the Federalist Society? What then would you say? Would they be able to attend a meeting that was sponsored and it had to talk about maybe some conservative or libertarian issues?
I don't see why a judge shouldn't attend that as a spectator.
Okay, well then you're also asking the Congress to change the process by which judges can recuse themselves from hearing cases. So what's the current process now?
You file a motion. The judge grants it or denies it. If the judge feels so inclined or thinks it's appropriate, he or she writes an opinion, but often that is not done. And then that's it, basically.
Well, and so what's so wrong or bad about this lack of a process almost, because it's been that way for quite some time now? Why are you requesting it to be changed?
Well, one thing that's requested in the letter of the law teachers is that if the judge does deny a motion to recuse, the judge should state reasons. That itself, I think, is a useful check that our whole judicial system is built on, that stating reasons helps ensure that people will act in a consistent and sensible way. Beyond that, we're requesting that there be some procedure for review, because there's something strange about a judge who is alleged to be biased or to give the appearance of bias deciding for himself or herself that he is not biased, and that being the end of it. It's not limited to Supreme Court justices. It should be true for everyone.
Well, and I remember there's one famous example in recent times of this sort of self-judging, and that is with Justice Scalia. He refused to remove himself from hearing a challenge to Vice President Dick Cheney's Energy Task Force after having gone duck hunting with Cheney in 2004.
Correct.
So, I mean, that's kind of a perfect example of self-judging, correct?
Right, and there are a few other opinions released by Supreme Court justices which are the same.
Well, and I have to say that Stephen Gillers, who is a NYU law professor, he actually didn't sign this letter. His signature is notably absent from it. And he said the reason why he didn't sign it is although he agrees that there needs to be a mandatory code of ethics for the Supreme Court justices, he didn't know whether about the process for recusal and what we are actually asking for recusal. He said that the approach that everyone's taking here might create this opportunistic behavior aimed at keeping a colleague on or off a case, and it also could destroy or ruin the collegial or collegiate atmosphere that the Supreme Court justices now enjoy. So how do you respond to that criticism?
Well, that is certainly a possibility, but there might be ways of dealing with it. For instance, the review would not necessarily have to be by the other sitting judges. You might have a panel of retired judges.
Or other experts.
Or other experts, conceivably, passing on this. There are also a possibility of having advisory opinions so that the judge could seek advice on an issue. And that process does indeed exist under the ethics code that federal judges, except for Supreme Court justices, have to follow. So some of the issues have already been settled. A certain amount of case law builds up, and then when the same problem arises, it's not necessary for the judge to take the responsibility, which I'm sure lots of judges don't particularly like, of saying, I think I'm obliged to sit in this case, even though there are people who are saying I should not.
Well, and I think the goal here is pretty clear, that you'd like to preserve the integrity of the court, maybe even restore some public confidence in it. And so if there is a code of ethics that's actually in play for the Supreme Court justices, I wonder what it might mean for certain justices, like individually. For example, would or should Clarence Thomas be asked to step aside if and when the court takes up one of the health care challenges, because his wife, Virginia Thomas, has been a very outspoken opponent of the health care law?
Well, I don't think his wife's opinions should be decisive. And curiously enough, I just read an opinion from the other end of this political spectrum, Judge Reinhardt of the Ninth Circuit, who's perhaps one of the most liberal judges in the country, was asked to disqualify himself from one of the gay marriage cases on the grounds that his wife is the head of the local civil liberties union, which is very much in favor of gay marriage. And he says, well, no one's going to believe that no one should believe that my opinions are going to be affected by my wife's, or vice versa.
Oh, wow, that's pretty interesting.
So, and I think it's true that if Justice Thomas and Judge Reinhardt were to, as it were, trade spouses, they would still be writing the same opinions that they're writing now.
I think you're right about that. Well, the other question that I have for you is Congress actually empowered to address your request in this letter? Are they able to answer it and do what you're asking them to do here?
I believe they are. They certainly have passed one recusal statute which purports to apply to justices. That's Section 455 of Title 28 of the U.S. Code. So if they can do that, I don't see why they shouldn't be able to pass a code. But it's also possible for the court to issue its own code.
Do you think they might?
I don't know, but one certainly shouldn't assume. I think most justices take impartiality pretty seriously. Mm-hmm. They often do disqualify themselves, and no one hears about it because it just has happened. No one had to ask them. So it isn't really an issue in which they should be viewed as on the defensive in some way. It's a question of how should the problems be addressed, and one can understand that, as Steve Giller said, they might be sensitive about seeming to regulate each other, but they certainly, that might be the ideal way for them to handle it.
Well, and there have been some critics who have said that this highly politicized debate should occur in a more neutral time. So what do you say to those folks who say that now is not the time for this conversation?
Well, considering how the Supreme Court is involved nowadays in so many issues, I don't know when this neutral time will come.
I agree with you.
And when it does, no one will be much interested in the issue. So, as I said, the reason these decisions are made is because there is public concern. However, they could, for instance, set up a committee to draft the code, and you know, they could arrange that it would come into effect in 2 years. I don't think it's necessary for the court to commit themselves as to the particular conduct of this justice or that justice.
All right, well, we're going to have to leave it there, but I have to say that the ball is in Congress's court now, so we'll see what they do with it. And your efforts here have raised awareness of the need to bring more transparency to the court, so thank you very much for sharing your insight with us today.
No, I was glad to be here.
When we come back, our spotlight on contributed content. Back in a moment.
Digital technology has transformed the way we live our lives. We can access any piece of information at any time from anywhere. We can share ideas with thousands of people instantly. Staying up to date with breaking news and events is easier now than ever before. All this lets us keep pace with the world in real time. Yet, have any of these innovations been applied to the way we research and practice law? Starting today, the answer is yes. Welcome to Bloomberg Law, the first and only real-time research system for the 21st century legal practice, created by the leading provider of data and information services. A single search feature with access to legal, news, and company databases provides you with powerful legal research results and a holistic view of your clients, filtered so you know the information you receive will be relevant every time. Customizable legal, financial, and news alerts keep you ahead of your clients and in tune with their world. An integrated workspace allows you to organize your results by client, by urgency, by topic, however you want it, and to share those results with people on your team. Log in now to experience Bloomberg Law.
Now it's time for our Spotlight on Contributed Content. This is a segment where we highlight an article that was featured in one of our Bloomberg Law reports. Today's article comes to us from Barbara Hoey of Littler Mendelson. The title of the article is Preventing Violence in the Workplace When the Company Calls 911. What's great about this article is that not only does it discuss several steps employers should take to ensure the safety of their employees, but it also explains how employers can do so without succumbing to the prejudice and ignorance concerning mental illness. You can find this article in the March 7th issue of our Bloomberg Law Report, Labor and Employment, on the terminal at LELR-Go or at BloombergLaw.com. Articles are contributed to us for publication by practitioners, law professors, and other legal experts. To find out more about how you can contribute, please visit BloombergLaw.com. A special thank you to Barbara Hoey for that contributed piece. And again, our thanks to Professor John Leubsdorf of Rutgers Newark Law School. Bye, everybody.